Good morning, good afternoon, and good evening to all the participants. On behalf of CNICA, I extend my warm wishes and welcome all the participants for today's study series. Distinguished and diverse participation is in itself extremely encouraging. As always, you have been a wonderful source of support and inspiration for CNICA to conduct the study series. Today's topic to the study series is domain name dispute and arbitration. Domain names are simple form of addresses on the internet, just like how we have addresses to our homes and offices. Domain names are analogous to offline trademarks. It serves the same purpose online, which a trademark serves in the offline business transaction. They indicate quality of a company and serve as its repository of goodwill. They serve as an essential identifier for business, and therefore the preservation and protection of domain name is of paramount importance. While the trademark allows two or more users of a same or similar trademark for various classes of goods and services under the pretext of honest concurrent user, so long as there is no infringement or confusion or dilution. However, such kind of provision is not available in the case of domain names, as there can be only one user of a domain name. Internet has brought massive revolution in the 19th century, equivalent to or even more to the 18th century industrial revolution. Internet has proven itself as one of the most dependable means of assimilating and disseminating information. While electronic commerce has flourished with the expansion of the internet, recent developments in the domain name registration system have fostered practices which threaten the interests of a trademark owner and cause consumer confusion. Domain name registration system started on the basis of first come, first served basis. The registrant authority, which was initially the internet, did not have the responsibility for checking the ownership of the name. With the explosion of internet, large companies attempted to leverage the goodwill obtained by the trademark offline in the online cyberspace and desired to enter the internet with their own websites, and often found that the domain name they were seeking had already been booked. These companies felt ripped off and deprived of the legitimate rights, and often had to pay a price which was sometimes unimaginable. This increasing cost of buying back of domains resulted in trademark owners coming together and claiming that their intellectual property rights on the registered trademark should be extended to domain name. This has resulted in considering registration of domain names without the intention of using them as cyber squatting. The other popular form domain name abuses are typo squatting, reverse domain hijacking, and phishing. Now a domain name is acquired through a simple contract with the registry, and any rights which the holder has in respect of the name derived from the contract. However, successful registration of a domain name with an accredited domain name registrar does not confer any legal right to use the domain name beyond those created by the registration agreement itself. By virtue of the incorporation of the Uniform Domain Name Dispute Resolution Policy into the registration agreement, the registrant submit itself to the jurisdiction of the approved dispute settlement resolution provider and binds himself to the UDRP. Now, what are the ways which are available for a trademark holder when the domain name is abused? Either, number one, you can either the trademark holder can buy the domain name from the cyber squatter. This would be unprofessional as it involves giving it to malpractices. Otherwise, the trademark proprietor can file a lawsuit in a court of law. However, this is an expensive and slow process. The third alternative is the trademark proprietor can go for arbitration proceedings under Uniform Domain Name Resolution Policy, UDRP, developed by ICANN. Here an expert decides the case, the proceedings are transparent, it's time effective, cost-effective, and decisions are enforceable. We have with us today an intellectual giant, one of the eminent men of law and the Queen's Counsel, Honorable Neil Anthony Brown, a multifaceted personality. His versatility embraced many fields with a most colorful career. He has a charm bordering on charisma. His indefatigable industry and unremitting toil and meticulousness with a keen eye for detail has impressed the best in the legal fraternity. He carried his distinction and achievements with humility and ease. The Queen's Counsel will elevate the topic, domain name, dispute, and arbitration. May I request our chairperson, Sri D. Saravanan, to welcome today's speaker, the Queen's Counsel, Honorable Neil Anthony Brown. Over to you, Saravanan.
Thank you, Ashok. Thank you, Mr. Anand, for your exhaustive welcome address defining the domain name and domain name dispute system. My warm wishes to one and all, and my respects and greetings to the Honorable Neil Brown. A domain name is one's website name, which is the address where internet users can access the website. It is no surprise that ever since the recognition of internet as a tool for advertisement and marketing, there has been a widespread increase in the number of the domain name disputes. When a person or a company find that the domain name corresponding to their corporate name or product trademark is owned by someone else, the company can either choose a different name or fight to get the domain name back from its current owners. When a dispute or cyber squatting over a domain name occurs, the parties can always turn to the state courts. However, it is open secret that the judicial process is slow. Hence, the agreed parties are turning towards the resolving the domain name disputes under the domain name dispute policies. In India, domain name disputes relating to generic top-level domains are governed by the Uniform Domain Dispute Resolution Policy, whereas disputes pertaining to country code top-level domains are governed by the .in Dispute Resolution Policy, which is overseen and managed by the National Internet Exchange of India. The .in Dispute Resolution Policy was formulated in the year 2006, following the footsteps of Uniform Domain Dispute Resolution Policy, and is in line with the rules of procedure set out by the World Intellectual Property Organization. The resolution of domain name disputes under the policies are gaining its popularity on account of its ease of procedure, uniformity in policies, no territorial restrictions, proven efficacy, speedy, less cost, and a rapid enforceability. To speak on the subject, we have today with us the Australian politician and a lawyer, arbitrator and mediator, the Honorable Neil Anthony Brown. If we talk about the credentials and accolades of Neil Brown, it would take the entire time of this webinar. However, I would like to restrict on the very important aspects. Mr. Neil Brown was born on 22nd February 1940 in Melbourne, Australia. Mr. Neil educated at the University of Melbourne and graduated as Bachelor of Laws in 1963. He was admitted to practice as a barrister and a solicitor of the Supreme Court of Victoria, 1964. He was a resident tutor in law at International House and Ormond College, University of Melbourne from 1963 to 1968. He was admitted as Queen's Counsel in 1980. Honorable Neil Brown started his career as a barrister. His practice at the bar encompassed commercial law, constitutional, intellectual property, administrative, construction, town planning, and industrial relations. He has appeared in state Supreme Courts, the federal and high courts. In the field of intellectual property, he has acted as counsel in several intellectual property matters concerning designs, plans, photographs, copyright, trademarks, and passing of claims. During his career as a lawyer, he had thrice become a member of the Federal Parliament of Australia, and he had thrice become a minister in the federal government in the business and consumer affairs, employment, communications, and attorney general's portfolios, and was a deputy leader of the opposition. He was a delegate to the United Nations and other national and international organizations. He was also an observer of independence elections in Zimbabwe. He is qualified and experienced as an arbitrator, mediator, and conciliator. He is a leading and international renowned domain name arbitrator and advisor. He is a fellow of the Chartered Institute of Arbitrators and adjunct professor at Murdoch University, Western Australia. He is the founder of the website www.domainnames.info, an authoritative commentary on all domain name issues. He has also contributed to debate on domain name issues through his website. He was appointed by World Intellectual Property Organization, Asian Domain Name Dispute Resolution Center, American Arbitration Association, and National Arbitration Forum to a series of panels to adjudicate on disputes arising under the new generic top-level domains, as well as panels to arbitrate on regular domain name disputes. He is also one of the panelists of ICSID, SEATAC, and many other internationally renowned arbitration and mediation centers. Mr. Neil Brown has contributed papers to journals, most recently on anti-suit injunctions, interest on arbitration awards, and the article, the Arbitration of Celebrity Domain Name Disputes in the International Trademark and Business Law Review. Mr. Brown has also sat on arbitration moods, contributed to conferences on arbitration, mediation, and domain names in Australia, Hong Kong, Seoul, Vienna, Paraguay, Geneva, and lectured to master's students in Melbourne. Sir, I am also happy to recollect that I had an opportunity to sit with you as one of the arbitrators and decide a domain name dispute, which is a case of reverse domain hijacking. Today, we feel happy and proud to be with you, sir. I request you to take the digital dais and deliver your presentation. Thank you, sir.
Program just to hear a very glowing report about somebody being introduced, and I found to my surprise that it was me. So I must thank you, and I will just simply reply by saying that if I ever contemplated, if I went mad and were contemplating going back into politics, I would engage you as my public relations agent, because you do a very good job with a very hard case. So thank you very much for that. Now, ladies and gentlemen, in the hope that there might be one or two of you still there, could I say good morning and good afternoon and good evening, as the case may be, and say that I appreciate the opportunity, doubly appreciate it now because we can communicate with each other. I was thinking of introducing my remarks by saying something of the UDRP, the Uniform Domain Name Dispute Resolution Policy, which is actually equally applicable to Zoom. So I think it's very appropriate. I could say the same thing, that those of you of a literary or historical turn of mind would no doubt be familiar with the diary of Samuel Pepys, who one day earlier in the 18th century went down to the City of London and saw a dog walking on its hind legs. And he was very impressed by this and wrote in his diary that the most astounding thing is not how well this was done, but that it could be done at all. So I suppose we should be grateful that Zoom allows us to communicate at all in this form. And let us hope we can use it for a little while tonight to discuss this very worthwhile subject that that we have for discussion. And I suppose we could put my comments in the nutshell that I have already expressed, namely that I am an advocate for the Uniform Domain Name Dispute Resolution Policy. I think it's not perfect, but then nothing is. But it's as close to perfect as a good arbitration system could be. I think what I might do, in the hope that we could catch up with any time we may have lost, by going to the slides, not that we will stick with them entirely, but we could go to the slides that I've submitted and take them one by one and see how we go. And lo and behold, by some magical, mysterious process, there it is. It actually works. And I'll take you through those, not solely so that you can see my photograph several times, but because it seemed a sensible way of breaking the presentation up. So if we could go to the first or second slide, rather, the next one, And there we are, that works also. And I just wanted to introduce it by saying that we're dealing tonight with an important area of arbitration. There've been this next statement is a bit out of date, actually, because there are certainly more than 50,000 decided cases. And when you think about it, that must really be about the largest arbitration system that there has ever been. Actually, to have done 50,000 cases is a monumental effort. And the decisions of arbitrators in this field, if you look at them, will establish that proposition that there have been really so many cases dealt with, each one of which, of course, has resolved a dispute in one way or another. And the decisions are all made public, so the whole process is open for everyone to see, and they're public on the websites of the various providers of arbitration services under this scheme. So we might just pause there and look at this for a minute to make the point to you that there are now 6 arbitration providers who deal with domain name disputes under the Uniform Domain Name Dispute Resolution Policy. And I list them because they're each in their own way very competent. I assure you they are all professional. They play an important role in this process because the complainant, that is the person who has the complaint, the person who wants to start an arbitration process, has a completely free choice as to which of the providers, all approved by ICANN, which in effect runs the internet from Los Angeles, all approved. You have a choice, if you are a complainant, of lodging your claim in whatever arbitration provider takes your fancy. You will probably stick to the one you've used before, but I think it's good to keep in mind that there are now 6 providers. I can speak with intimate knowledge about all of them with one exception, which I will mention in a moment, but I'm sure it is doing its own job. WIPO at the beginning is the World Intellectual Property Organization. Forum, the second in that list, is the one that some of you would know as the National Arbitration Forum. It is now known as Forum, based in Minneapolis, which does a very large number of American claims by American complainants. The third one is the Asian Domain Name Dispute Resolution Center, based not in any place in particular, actually, because it's a combined effort of Hong Kong, China, Malaysia, and South Korea. The Czech Arbitration Court is the next one, based in Prague. The 5th one is a comparatively new one, which is the Arab Center for Dispute Resolution, which is not very active in this field. It has done about 9 cases at my last check on that. And then there is the most recent provider appointed by ICANN, which is now well underway, our Canadian friends, and those letters stand for the Canadian International Internet Dispute Resolution Center, based but in no sense confined to Vancouver in Canada. So just making that point at the bottom before going on to the next slide, I think it's worth while noting that just before, if you could just go back to the previous slide, just to finish that off, that there are several national bodies that also handle what we call country code domain name disputes, of which the obvious one, in view of what we're doing tonight, is the Indian registry. The .in registry is responsible for disputes confined to .in cases. So we can go on to the next slide and have a further look in a bit more detail about what we're dealing with tonight, because it's important, I think, to get that straight. What we're looking at tonight is the arbitration of disputes over domain names dealt with under the UDRP, which you have already had explained to you by the previous speaker as to what it is. It should be said, and I think it's often overlooked, that this is a great improvement on court proceedings, but court proceedings, civil litigation, is still available. It is available before or indeed after an arbitration under the UDRP. But in my view, and I think it's the view of virtually everyone associated with this field, is that the UDRP and the arbitration process provides extraordinary benefits which are not available in litigation, and make the process actually far more valuable to all concerned than would litigation in the courts. Those of you who have had the debilitating experience of engaging in international litigation in courts would realize that it's basically a nightmare. You have to find your defendant. You have to work out where you're going to sue. You have to get those proceedings launched. And of course, not the least of your problems will be what system of law is to be applied. Whereas under the UDRP, the arbitration process, it's an arbitration process, as the words imply. The rules of the game specifically say that the arbitrators, or panelists as we call them, are to have regard to what is proposed in the UDRP itself, and then it has a catch-all provision after that, which is probably every lawyer's dream, because it provides in the policy that the arbitrator may also apply any other principles of law which the arbitrator is of the view is appropriate. So that gives a very, very wide scope to arbitrators to apply sound principles appropriate to the whole process of the internet and domain names to get a good result. And what you get, I've set it out there, that's not exhaustive, but what you get, which you don't get from litigation, not to the same extent as you do under the UDRP, you get a result, which is a great achievement. Often you meander around through court litigation year after year and don't even end up with a result. You get that result quickly under the UDRP. You get it economically. It's comparatively cheap. I was just looking up the figures. I don't want to give you the costs for all of the providers of arbitration services, or will be here all night. But if you just took the figures provided by WIPO, which is one of the providers, it will cost you $1,500 to lodge a claim before one panelist at WIPO, which is minuscule. It's almost non-existent compared with even the deposit you would be paying your lawyers and others for litigation if you're engaging in international litigation in a system of courts, especially foreign courts. So you're getting it much more economically. As a matter of interest, if you go for a 3-person tribunal, which you can, you're not obliged to stick to a 1-person tribunal. You may have a 3-person tribunal at your own behest. That will cost you initially $4,000, of which I might say the panelist does not get very much of that. WIPO gets a fair slice of it to pay for their administrative costs, and the poor panelist is given a modest proportion of it to recognize his or her labors in this field. We have a new entrant who's come into this meeting, apparently. I know that because it comes up with a sign that obliterates my slide. I can't read what's on it, but I can now. And I just make the point finally in this area that one of the great advantages of the UDRP proceedings is that the decision you get is enforceable. You don't have to register it as a judgment under the New York Convention and then start the whole war over again for another 5 years until you can get your award registered and then enforced in the foreign tribunal. The end result of a UDRP proceeding is that the order is made, say if the complainant wins, the order will be made that the domain name is transferred to the complainant. Well, that will be done by the registrar, and there's a very good sanction to ensure that the registrar carries out that order, and the sanction is that the registrar will run a risk of losing its accreditation and the income of billions of dollars it earns every year from the sale of domain names if it does not behave itself. So there's a very effective sanction to it to encourage it to implement the decision which it is ordered to implement by the decision of the arbitrator. And you get also finality, one thing you regrettably do not always get in international court litigation. You will get finality, more or less. The decision is final, there is no appeal, which gives panelists a wonderful feeling as they write their decisions that this decision is not subject to appeal. The parties, of course, can go off to take court proceedings afterwards if they want. Very few of them do, and to all intents and purposes, the decision of the arbitrator is final. So that is I hope, not an over-optimistic assessment of the UDRP. It happens to be my view, and as I've already said, my basic proposition to you is that this arbitration system is good. It's served the test of time since 1999. It has resolved a large number of disputes, which are then, for all practical purposes, finalized and out of the way. And if we go on to the next slide, we will see another installment of this mysterious process, which I'm doing my best to advocate for tonight. Now, particularly because we have missed a bit of time getting up to this point, let me say quickly, I'm not going to insult your intelligence by telling you what domain names are. You know what domain names are, but I just thought it might be useful if we had a quick, very brief run through to refresh our memories. If you look at the second line of that exposition, I've given an example there of a domain name and a corresponding country code. A very popular field of domain names is the .com space, as we would call it these days, and a corresponding national one might be the one in Australia, which is expressed as being .com.au. Now, let us look at these alternatives I'm about to present before you for a bit of variety and give you a handy guide, I hope, as to what they all are. The reason for that illustration of the umbrella there, by the way, is that the only way I could understand this at the beginning when I started in this field in the late 1990s was to see it as an umbrella, because under the umbrella you have the whole variety of services available under the scheme. Look at davies.com.au. That is a domain name, davies.com.au. It is an Australian domain name, and if you look at what is under that, which is often seen if you're pursuing, say, the Davies company, www davies.com.au is not a domain name, no matter what anyone tells you of whatever authority. It is not. What it is an instruction to your computer to go to the World Wide Web, and in particular go to the .au part of it, then to the .com part of that, and then to the Davies part. So that will get you into the website, which is supported by the domain name we have just had a look at, namely davies.com.au. Look at the next one, which also concerns Davies. There's someone named John Doe, and you will see that expression, John Doe at davies.com.au. That you would instantly realize is an email address to a destination supported by the domain name. So there again, the domain name is important. Look at the last one, which is quite interesting, and actually it's an organization similar to yours, I should say. It does domain name arbitration. Excuse me, a highly regarded body in Australia. Its domain name is unusual, isn't it? Because it's resolution, which is the name of the body, .institute. How does that come about? That comes about because ICANN, responsible for the internet, has been embarking for a few years now on expanding the number of top-level domains, or umbrellas, if you like, and has established one, which is .institute. So you may obtain a domain name under that umbrella, which of course was very convenient for an organization like the Resolution Institute, which included the word institute in its name. So that's a very, very good example of the great attraction of the expansion of domain names by ICANN over the last 5 years or so. So what we have, there's a bit of a summary there at the bottom just to get you into the loop again. We have a whole range of what you might call the current or the original big league of, excuse me, of domain names ending in .com, .biz, Asia, .au, and all the rest of them. And then the beginnings of the new range. .Nike, .New York City, .Melbourne, and .Sydney, for that matter, are well established. .food, .gay, and so on and so forth. There are now hundreds of them, which are listed on the internet. And I think, although they haven't all been taken up with the enthusiasm that perhaps some people had hoped for, they are in very wide use and are very popular in use now. Needless to say, there are disputes about who is entitled to the new range of domain names, just as much as there has been a dispute and continue to be disputes, many of them, as to the entitlement of people to own or hold the old range of domain names. But if we then go to that next slide, we will see something else, which is an interesting way of looking at things. And it asks the question, what are these disputes that we are concerned with tonight? Well, it's not a watertight scientific analysis, but I've myself set them out in what I think are probably 4 categories of disputes. And you, I think, in some cases would not be surprised that disputes arise under these cases. First of all, there are what you might call genuine commercial disputes, say concerning agents in business. There is a company with an agent. They have a falling out. The agent has registered the domain name in his own name, and he says, this is mine. The company, his principal, says, no, it's not. You registered that as our agent. And the same exists quite frequently in the case of partnerships, and notably with distributors. If there is a distributor sale of motor cars in a locality and registers the domain name BMW Melbourne.com, and the distribution authority comes to an end, and that party is no longer the distributor. Who owns the domain name? Who is entitled to it? Could BMW bring a successful claim against its former distributor? Would the distributor have any defense? They are the intriguing questions which are then examined in the dispute resolution process, which is our subject of inquiry tonight. Then, although secondly, this group overlaps, obviously, a number of other analyses and categories, cyber squatting, which is a flexible word people throw around a lot. By and large, what it means is where a party has created a domain name which is a sort of echo or mirror of a trademark, a well-known trademark in either their business or in another business. They may have nothing to do with it at all. But they're sitting on it, hoping, of course, this is what a cyber squatter does, hoping that he or she or it will be able one day to cash in on their good luck, and encourage, if not force, certainly tempt the trademark owner to buy them out, and that frequently happens. It's not a wise course for companies to follow, to pay out on green mail, but it is done, and you'll see a couple of examples of it tonight. Then there is a quite large and important category of cases which really revolve around fraud and counterfeiting, where a mischievous party takes a domain name which is a copy of a commercial trademark, uses it to engage in a conspiratorial fraud to extract money illegally from innocent victims, or to sell goods which are really counterfeited goods. Jimmy Choo is there simply as an illustration. That's an actual one of an attempted sale through a website of counterfeited Jimmy Choo shoes. Prestige celebrity brands are sitting ducks for that sort of action being taken against them, and therefore those cases are important. Now, the other category, of course, which is always said to be one of the big failings of the internet and the domain name process, the use of domain names for pornography. Pardon me. It happens, of course, and it happens a lot, and will continue to happen so long as human beings are what they are. But one should not think that all use of domain names or all improper or illegal use of domain names fall into the use of them for pornography. I can tell you it's very large, but it is not in any sense either the main or dominating area of improper use of domain names. We will see some more of those in due course. If we could go to the next slide. And we will see when the next slide comes up what it is. You know now, I think, what the UDRP is. It's a compulsory arbitration process. How does it become compulsory? It becomes compulsory because when you buy or acquire a domain name, you enter into an agreement with a registrar who is accredited by ICANN, this powerful non-profit company, so they keep telling us, in Los Angeles, which in effect runs the internet. It accredits registrars, and they issue domain names to members of the public. They have a contract in writing, and ICANN has imposed the rule that when you do that, you must insert in the contract between the registrant of the domain name and the registrar, you must include the UDRP as the means of resolving disputes as to the ownership or entitlement to the domain name which is being purchased. So it is incorporated in their agreement with the registrar with whom they register the domain name. That's where the UDRP comes from. And it's the real fountain of jurisdiction. It's the source of the jurisdiction of everything that we're talking about tonight. And we will see some more of it when we move to the next slide, which we now will. This is here as an illustration to show you what these cases are like. It's a fairly well-known case. Madonna, the entertainer, brought the claim. It's a claim there on the website of WIPO for you to read. You will see it's a claim by Madonna, who is the complainant. It is against Dan Parisi, who is a not entirely unknown person who registers a lot of domain names. The domain name was madonna.com. It was registered with a registrar, Network Solutions, and it was linked to a pornography site, which Madonna did not like at all. I can assure you, she got quite upset about it and brought this claim. She was and is one of the comparatively few celebrities who actually has a registered trademark. So she got to first base on the claim quite easily, and she succeeded in making out the entire claim. The result is that she won, and that website is now hers and is used, of course, to promote her wares, her business. So if we can go to the next slide, we will continue on with this to see what happens about these things. The dispute as to who is entitled to the domain name is, of course, resolved under a system of law, which is applied in these cases by the UDRP. And here, for the second time, I mention, and it deserves to be mentioned many times, is that the rules of the game provide that the panel is to apply, amongst other things, any rules and principles of law that it deems applicable. There is a running dispute, for instance, as to whether a panelist or arbitrator should apply what we in the law know as laches. If the trademark owner who is complaining about somebody else using his trademark in their domain name, if he has sat on his rights for 15 years and done nothing about them, should that be a bar to the proceedings? Some people say, well, you should not even look at that sort of rule when you are dealing with an arbitration dispute, and certainly not under the UDRP. Others say, why not? If I, as a panelist, believe that that is appropriate to apply in this case, then I will. And sometimes it is applied, not always, but sometimes it is. Now, what is the outcome of these cases? The outcome is more likely than not a transfer of the domain name to the complainant, such as Madonna. She won, so the order was made that the domain name be transferred to her, and then it becomes her property. Alternatively, there is power simply to cancel the domain name rather than transfer it to the complainant. You can have it just cancelled. a lot of people do not like that as a solution, and logically it does not have a lot to commend it, because it might well be the case that the domain name is cancelled, but if it's cancelled, then the next day someone else, in theory the same person who held it previously, can turn around and register it again. Nevertheless, some complainants, one in Australia, for instance, Telstra, in the limited experience I've had of cases involving Telstra, they actually asked for cancellation. I think it's probably because big and busy companies do not want the continuing stress and strain of administering a whole stable of domain names and paying the registration fee year after year. So they say, just cancel it, just cancel it. If it's registered again by somebody else, we'll cross that bridge when we come to it, but we can just cancel it now. The other result, of course, as you see from the last point, may be that the complaint is denied. In other words, the trademark owner fails, the person who is the registrant of the domain name succeeds, and that party then keeps the domain name, and the arbitrator makes an order that the domain name remain with the respondent. And if we go to the next slide, we will see a bit more about how this drama unfolds, and I hope you're following it with me so far. What is the likelihood of success? I used the expression a lawyer's dream before. This is a sort of, the field is almost a plaintiff's dream, I think, because plaintiffs or complainants win most cases in this field. They win most cases because most cases are not defended. So complainants get off to a good start. Often the respondent who has registered the domain name knows, well, the game is up, they've made a claim, I can't extract any green mail from them, so I won't even bother defending it. Sometimes they consent. And I should say, because we were hoping to have some questions tonight, I already have a question in writing from one of your number who is present, which is about this process of cancelling domain names by consent. Often the respondent will consent unequivocally to the transfer of the domain name, and for a very good reason from their point of view, namely, they do not want a black mark against their allegedly good name, because in the next case, which they really do want to fight over, it will be used against them. However, as you see from this, these are only WIPO cases here, which the pie chart is concerned with, and they're a couple of years out of date, but the theme is still the same. 83% ended up with a transfer to the complainant, 15% the respondent won, and that very small percentage, 0.92%, were cancelled. Just to give you an idea of how this fares in other jurisdictions, in the Australian domain name space, it's interesting that the complainant, the arbitrators, the panelists, are a bit more draconian there. You'll see that they only ordered transfer of the domain names these days in, and this is based on several years, 72%, whereas denied, in other words, where the respondent won, that was in 26% of the cases, whereas it was actually fewer than that in the .com big league, at least that part of the big league administered by WIPO, and 2% were cancelled. So if we move on to the next slide, we will come close to finishing the background of what this system is and how it is faring. Procedure, by and large, probably does not come as much of a surprise to you. After all, it is a dispute, It's a dispute which is being looked at by an independent body, namely the panel, the arbitrators, and therefore some basic rules that you would expect to see are there. The case starts off with a complaint, which is pretty much as you would imagine it to be. The complainant sets out their argument, containing their evidence, and I must emphasize, as I will be doing several times tonight, that the evidence adduced by the complainant, and in an appropriate case, the evidence adduced by the respondent, is the most important, tremendously important part of this whole process. So the complaint comes forth. Again, something that appeals very much to lawyers is you don't have to worry about serving the documents on the respondent, because the provider of arbitration services does that for you. If the respondent wants to put up a fight, they will file a response. The provider will then appoint a panelist or 3 panelists by various processes set out in the rules, and those panelists will decide the case. The panelists will give a declaration that they are independent and they will keep an open mind and generally behave themselves in the course of the proceeding, and then there is a decision. Now, I'm not going to, you will be very pleased to hear, take you through all of these rules of procedure. It's probably the subject for another day, but can I simply say that you will find on the internet a wealth of information if you want to bring yourself up to speed on what the rules of the game are and how they are applied and the sort of results that you might expect. You can look at this work called the WIPO overview, which gives one view on a number of issues. It doesn't cover all views, in my opinion. You'll find a useful index of decision in WIPO cases there. And I should say the other providers also have their own indices, and they are also another wealth of information, but I want to compress it to as much as I can. And I've mentioned there this very learned and uplifting publication on the internet called domaintimes.info. That is my website dealing with this field, where I try, with the assistance of Max and some other keen assistants, to give the internet and domain name community a heads up fairly regularly on what sort of cases are being decided, what trends are emerging, and any gossip or scandal that there might be floating around, or news or current affairs, as we more politely refer to it, to try to keep people up to date. One of the really very good things about this UDRP system is that there is no shortage of sources of information and people around, not just me, but others around, whom, if you have any problem whatsoever about domain names, please talk, ask questions, communicate, either with me, any of the other panelists. I saw Philip Argy there before when he made a cameo appearance on the screen with the Sydney Harbour Bridge behind him. I know Mr. Alan Limbury is also here, or was intending to be here. And really, any of the established panelists will be only too happy to assist you and argue out any problems that you have in this field. So that's the procedure we have established to resolve our dispute over who is entitled to a domain name and who is not. So if we go on to the next slide, we'll go down a bit deeper now. Could we just go back to that one? Yes, very briefly, could we say that as the complainant is bringing the complaint has an obligation or an onus to prove things. And they have to prove three elements that we'll have a look at in a minute before it can succeed in having a domain name transferred to it or cancelled. Don't forget, the complainant must prove all three of these criteria and must prove them by evidence. The bottom of that slide is being chopped off and I can't see it, but I hope that what it says is that it's on the balance of probabilities being a civil proceeding. Just before leaving that slide, at the risk of, I don't want to bore you, but this is really so important that it deserves to be emphasized. You probably know the old story that if you ask a real estate agent what are the three most important criteria when it comes to selling a house, what are the three biggest factors that will influence getting a higher price? And real estate agents will always tell you there are three things: location, location, and location. I say that in the domain name field, there are three important factors, and they are evidence, evidence, and evidence. And the evidence is vital and important, A, because it is too frequently overlooked these days. Secondly, it's important because the policy, the UDRP itself says, what this is saying to me now is that your battery is running low. So I must talk faster, I suppose, before the battery expires. If you would excuse me for 30 seconds, I will just do something with this to make sure we don't get stranded in midstream. As is often the case, we are slaves of technology, and I've had to push the plug in a bit more firmly, so I think we will now not have that problem. The UDRP says that you must prove all of this, you complainants, by evidence. And evidence is a word that seems not to be universally understood these days. One of the things that strikes us as panelists, or at least strikes me, is what I think is an increasing number of complaints which are full of assertions and not supported by evidence. So evidence is tremendously important. Cases are lost. If you just skim through the decisions which are published, you'll find quite frequently panelists saying, there is no evidence of this point. This is an assertion. It is not evidence. So I just make the point, without harassing you too much about it, that it is an area which, in my view, lawyers as a race are not adequately dealing with, confining themselves to evidence, and that they should do so. You will win more cases if you concentrate on evidence, whether you are a complainant or a respondent, then you will win without evidence. So if we go on to the next slide, we will start to see what we have to prove. And the next slide will show us that the three elements which are set out in the policy, of course, that have to be proved are these three. First of all, there is one that looks at the standing to bring the claim at all, and the standing to bring the claim is that the complainant must show that they have a trademark or service mark, and that the domain name that they are chasing is either identical to that trademark or confusingly similar to it. The second veers away from that and has a look at the person who is the registrant and says, you must prove, this is to the complainant, you must prove that the registrant has no rights or legitimate interests in respect of the domain name. And thirdly, that the domain name has been registered and is being used in bad faith. Now, notice it's obvious to you, being intelligent people, but apparently not obvious to a lot of people, including lawyers, that all three of those elements must be proved because they must be, and they're connected by the word and. So that's the first thing that you must really absorb if you're going to become a practitioner in this field. And the next and equally important feature is that it must be proved that the domain name has both been registered and is being used in bad faith. Only as recently as 2 weeks ago, I sat as a member of a panel of 3 in which we were surprised to find a firm of lawyers submitting to us that what that last element means is that either you must prove that the domain name was registered in bad faith or it is being used in bad faith. You as intelligent observers would know that that is a lot of stuff and nonsense. And not only was it wrong and put the whole case of the complainant in that case completely off course, but it made the 3 of us, the panelists, wonder, although we didn't use such impolite language as this, it made us wonder whether the complainant's lawyers really knew what they were talking about. So if we go to the next slide, we will go even deeper into this intriguing area of the first of the 3 elements that has to be proved. Let me give you some examples, on the go, etc. I think you would agree with me, would you not, that if the complainant's trademark was on the go, then the domain name onthego.com is identical to the trademark, is it not? And I can hear you say, yes, it is. If we go on to the next slide, we will look at another case involving the domain name Dell Technologies. The trademark is Dell, the famous computer company. I think you would agree with me, would you not, that DellTechnologies.com is not identical to Dell because it has an additional word, technologies. But I think you would probably also agree with me that it is confusingly similar because we all know Dell is a technology company. So if you slide the word technologies in after Dell, you're virtually saying that what I mean in my domain name is technologies provided by Dell, the complainant. I think you would agree with me about that. But I don't know whether you would agree with me about the third one, which is one of a number of difficult ones which keep coming up and panelists have to keep arguing it. Well, the parties have to keep arguing about them. Say if your trademark is the safe and bolt and lock and key company Chubb, and some scallywag registers the domain name chubbsucks.com, sucks being a derogatory word, and what they mean by that, of course, is that they want to abuse Chubb and make a lot of very critical remarks about Chubb. That is not, is it, identical to the trademark Chubb, but is it confusingly similar? Is it similar? Well, I suppose it's similar in one sense because the word Chubb is in it. Is it confusingly similar? In other words, when a member of the informed public saw the words Chubb sucks, would they think that that was a domain name of Chubb or an outsider's domain name? I wonder. I will leave that intriguing question to you to think about, because if I start talking about that, we will certainly be here for the rest of the night and will not be advancing this subject much further than that. Suffice to say that the sucks cases, of which you just saw one, are an area of controversy, and each case on one of the sucks cases, the decision is written as if it was the first case in the area, because it gives rise to a lot of feeling, particularly amongst American panelists who quite rightly pay great respect to issues of freedom of speech. And they say, this is one that must be untrammeled. They must be allowed to do that. Other people say, no, no, no. You can say what you like about Chubb, but you're not allowed to say that you are Chubb. So we'll now go on to the next slide and move on, I think, a bit faster, just in case. But I want to make the point that what is pivotal to this whole process is that the complainant has to make out a case that it has a trademark. It may be registered or unregistered, meaning a common law trademark, and to all intents and purposes may have a trademark in any jurisdiction, but there must be one. It's not the same in all policies. For instance, the policy of providing or applying to .in, domestic Indian domain names, does not provide that the complainant must have a trademark. The requirement is a trademark, but also a name, trademark, or service mark. In other words, if you have a name, you can rely on the name. And if you have rights in that name, you can make out a case that the domain name which you're fighting over is in fact a breach of your rights as the owner of that name. It may be a company name or a business name. It may even be, I suppose, on the normal interpretation, a personal name. On to the next slide, and we will see that I like doing this way because it comes as a nice surprise to me to find what the next slide will say. And here we are. I'm refreshed my memory now. If the trademark is registered, that's a great help to complainants. As I said before, celebrities often forget to have trademarks in their own name. Many celebrities do not have registered trademarks, and they then have to show that they have a common law trademark, as Hillary Clinton did. When Hillary Clinton was running for the presidency, if we go on to the next slide, she found that the domain name she wanted to use in her campaign was actually owned by somebody else. But she was able to start off a complaint under the UDRP by showing that she was the publisher of books which were written and published in her name and sold, for which she received income. That meant that she was engaged in trade. Therefore, there was a good case to be made out, which was accepted by the panel, that she in fact had an unregistered trademark in her own name. And if we go on to the next slide, while I wet my whistle and have a mouthful of water, you can see from that, which was the search on hillaryclinton.com before Mrs. Clinton got her hands on it, that you can understand why she didn't want that floating around, what with references to Monica Lewinsky and all the rest of it. So she put up a really good effort to get hold of this domain name, and she succeeded, as you will see from the next slide. She has it all to herself. And it was actually the domain name she ended up using as her website for at least her most recent campaign for the presidency of the United States. Now, if we move on to the next slide, we will find that that was the way it has been used. It's now her domain name. her website and everyone is happy. Next slide, please. Take us to the second element, which, as I said, takes the focus, the spotlight off the complainant, which is where the first element was focusing, onto the respondent. And it says, in effect, that the complainant has to prove that the respondent, who is the registered owner of the domain name, shouldn't have it at all. They've got no right to it. We could again be here all night to analyze these words, no right or legitimate interest. I think you would know that rights are probably recognized as legal rights, and that's what it means in that context. A legitimate interest does not have to be a right, and certainly not an enforceable legal right. It is virtually, in layman's terms, a legitimate interest, which has been established, say, for instance, by being first to register the domain name. First up, best served. First up, best dressed. That would be a legitimate interest. A domain name registered by consent would be an interest. One that is registered to pursue a legitimate purpose. Say I registered the domain name because it was already the name of my company. That would be a legitimate interest. And if we go on to the next slide, we simply have the opening proposition there that if the respondent can show that they have a right or legitimate interest, you would know from what we've already seen that that means the complainant is not going to succeed in proving this second element, and therefore the respondent is going to win. So it's very important to respondents to try and win their case on this element of whether they have a right or legitimate interest in the domain name by proving any one of a number of things. If we go on to the next slide, we'll have a look at some of them to show what we can do. One which is actually set out in the policy itself is that I'm commonly known, the respondent is commonly known by the domain name. This is also an illustration of a very good proposition that you should choose your parents with great care when you're born, like the fortunate Mr. Mani, M-A-N-I, who actually was a gentleman who lived in Vancouver, still lives in Vancouver. I think an Indian, if I might say so. But in any event, he chose his parents very carefully because they gave him two given names, one of which started with the letter A, the second of which started with the letter R. And he ran them together and he said, well, I am commonly known as Armani. And that's the reason I have registered the domain name Armani.com, and he adduced a bit of evidence to show that that was the case. And really, although I wonder how many people believed him, really the reason why I have that domain name is that I want to set up a website for the Armani family, by which I mean not Giorgio Armani, I mean my Mani, and certainly not Armani. And that was accepted by the panel because the evidence was that he was known, commonly known by the domain name. There was no evidence to the contrary. However, if you look it up today, you will find that it is not devoted to Mr. Mani's family. If you go to the next slide, you will see what it is devoted to. Next slide, please. Hello, hello. It's devoted to Giorgio Armani, which tells you that Mr. A. Armani is probably on the beach in Acapulco or Monte Carlo, enjoying the proceeds of having sold that domain name to Giorgio Armani after he won the case. So if we go on to the next slide, here is another defense that the respondent can use. He may be able to show, I'm using this, and this again is set out in the policy itself, so there's no argument as to whether it's a defense or not. I'm using this for a bona fide business, and I was using it for a bona fide business before I had notice of the dispute. I was actually using it in my business, which was legitimate, was bona fide. That's why I had the domain name. That's why I registered it. And the policy quite rightly acknowledges that as a complete defense. But again, evidence, evidence, evidence. You can prove that, but you have to prove it by evidence. And if you do, the respondent will win. Another one which is set out there, that if it's being used for a legitimate non-commercial or fair use, then that again will be a right or legitimate interest, and the respondent will succeed if that is made out on the evidence. What do we mean by legitimate non-commercial or fair use? The next slide will tell us, if we can go to the next slide. Say a genuine criticism site, one which was really used for criticism, as was this one. I won't keep you to analyze all the details, but it was one of those typically, and I like them, it's a great thing to have an institute in the United States which is promoting the cause of free speech, which is exactly what was being done in the Sutherland Institute case. And he was successful. It was a genuine criticism site. So the man who somewhat courageously had registered SutherlandInstitute.com retained it. But again, if you look it up, you'll find that it's not his website, it's the Sutherland Institute's website. So it looks as if another sale has taken place. The next slide, please. It can be a fan site, or what's referred to often as a tributary site, where it is devoted to the worship of a film star or a novelist or an actor or whatever it might be, a genuine fan site, not just one that pretends to be a fan site and which is really a commercial site, but one which is genuinely a fan site. That also will give rise to a right or legitimate interest. And if we go to the next slide, we will find that it's moved on to the third and final criteria. And before I leave what we've just been talking about, I emphasize again, it's difficult, if not impossible, to lay down unbreakable rules about how you will succeed on the previous element, the right and legitimate interest, which the registrant has, because it all depends on the evidence and depends on the particular circumstances of the case. The third element really gets to the root of what this is all about. Did you register this domain name in bad faith? Are you using it in bad faith? I say again, registered and used, not registered or used. But notice the difference between the UDRP and the Indian policy, applying only, of course, to .in domain names, where it is registered or used in bad faith. I've set out a few examples there. I looked them all up. The Australian one is an or, it's registered or used. The complainant, in other words, would only have to prove that it was registered in bad faith or used in bad faith. Either will do. No need to prove both. That's the case in the Australian one. It's the case in the EU policy for the now very widely used .eu domain names. The Canadians have what I think is a very good rule. Their rule is that you must, it's not really an alternative. In one sense it is, but you must prove only that the domain name was registered in bad faith. That's the issue. Was it registered or not? The Singapore local rule is an or, and so is that US, which is meant to be .us, not a widely used domain name, of course. The Americans are very keen on .com, but there is a popular range of domain names, .us, and that is an or one. So you must show bad faith. What is bad faith, you might ask? And you could also ask that same question. What is truth? But what is bad faith? One of those phrases, it's hard to put into words, although we all know what it is. But if we go to the next slide, we will get a few clues about what bad faith means. Because when we turn the page over, it's just an example of one of the criteria of bad faith, which is set out. That scallywag Austin Robinson is a real estate agent in Australia, and he registered the expression HarbordRealEstate.com, meaning, according to him, the generic expression real estate in Harbord. That view is not shared by the company known as Harbord Real Estate, and the panelists agreed with that submission. It was doubly bad because what Mr. Robinson was doing was parading this website based on the domain name Harbord Real Estate, which he'd set up as an obvious dodge to harm his competitor, who was in the same street of the town known as Harbord, or suburb known as Harbord in Sydney. And he was diverting hits on Harbord Real Estate to his own Austin Robinson website, which was really, you don't need, I think, to be told why that is bad faith, but you know that it is, because it's being deceptive to the community and the market. And if we go to the next slide, we will see my favorite domain name case, not only in bad faith, but I think overall. Some of you are old enough, I think, to have had a misspent youth by playing the computer game Legend of Zelda. I didn't, I should say. I was busy with higher issues. But I know some people had temptation thrown in their way and they went off playing computer games, and one of them is still Legend of Zelda. Young Alex Jones set up a website after he registered legendofzelda.com, which was a tributary site. He just followed the characters in the game. He had news and information. There is a bit of sale of this and that on the side, but nothing really substantially commercial. And Nintendo, who had been foolish enough not to register the domain name themselves, kicked up an almighty fuss about this and said, well, this is bad faith because you're using our trademark to promote your own interest in this game, whereas we should be doing that, and only us. The panelists quite rightly said, no, that's not the right way of looking at it. There's no harm in this. Sales of the game have gone up since young Alex Jones started promoting his interest in gossip and intrigue about characters in Legend of Zelda. Nintendo, you should be grateful that he's been doing it for you. You should have been doing it yourself. So the claim was dismissed. Regrettably, he kept it going for over 10 years. Regrettably, I looked it up today, as a matter of fact, and I find that it's clearly been sold now, but not to Nintendo. It's been sold to some entrepreneur who is using it for vulgar commercial purposes. It's being used to sell computer games. It's being used to sell all sorts of things. It's not owned by Nintendo, that's obvious. And that's a sad end to that. But while the case is there as a decision, it's a very valuable one because it tells you what bad faith is not. Now, if we go to the next slide, we have an example of something that is, again, clearly bad faith. If you have a trademark Novotel, and everyone knows that it's the Novotel chain of hotels, users will go to that domain name at its website assuming quite rightly that this is a website devoted to booking hotel rooms in Novotel hotels, which of course it's not. What it is an operation out in the shadows where they are taking Novotel's name without permission and using it for the purpose of running a private booking agency. So in other words, an act of dishonesty, an act of misleading. If we can go to the next slide and the one after that fairly quickly, I think we can, we'll just leave it, we'll leave it there as it is. But I think we can safely, no, back one, please, back one, that's right, just stay there. Where we were on bad faith was to sum that up by saying, there is usually some element of either misleading the public or being deceptive or selling counterfeit goods, pretending to do so, using the company's good name in their trademark for the purpose of a fishing expedition to get information from users, which you can then sell to some disreputable operation on the side, which will use that information. They are the sorts of things that will be said to constitute bad faith. Now, in one sense, in a conclusion, because you'll be pleased to hear wrap up in a minute, I've summarized it by saying that the UDRP is the vehicle for the compulsory arbitration of disputes over domain names. You can use that expression I've used a few times already. Who owns them, if you like? Who's entitled to them? Who is wrongly retaining them? That is what this is all about. They are the things we've been looking at to show how claims for domain names will, generally speaking, shake out. The drama goes on, of course, because of this introduction of several hundred new generic top-level domain names. What we have had are on the next slide. If you just look on the next slide, this is more or less what we had, the big and not so big league. But if we go to the next slide, we'll see what we're getting under the new regime of the new domain names. You can have a new domain name, top-level domain, consisting of virtually anything. Naturally, there will be disputes about should you set it up at all, and that is referred to very briefly on the next slide to show you some of the new ones which have been approved. And they are, I think most panelists and those here tonight or today would agree with me when I say that we now get quite a few disputes to arbitrate on, which come from these new domains, which are well underway now, like, for instance, anyone relating to brands, to places, generally to concepts or areas of industry, and they give rise to disputes. So what do we do about them? If we go to the next slide, we will see very briefly that even setting one up can give rise to disputes, and therefore ICANN has, as we will see on the next slide, been very good. One thing that ICANN has been very good at, I think, is to set up dispute resolution processes to resolve disputes. And by Jove, are they fought out with a lot of feeling. Disputes about, even before the GTLD is approved, before it's approved, whether you can have one at all, which is .New York or .gay or .restaurant. And then after domain names are issued, under the newly approved generic top-level domains. So they've set up a range of dispute resolution processes. If we go to the next slide, you will be pleased to see that you don't have to deal with that tonight because I've done it all for you. And you will find on domaintimes.info a paper which I wrote, and you will also find, it's okay, you can go on to the next one. You will also find that ICANN has set up some dispute resolution processes which are designed to help resolve disputes of the sort that are arising under the new generic top-level domain umbrellas. The URS, which is the uniform, not so very rapid suspension system, not so very rapid because it's not used a lot. To avoid going through the whole UDRP process, they set up this uniform rapid suspension system. They've set up one which deals with disputes about how the registry issuing new domain names is behaving itself, and whether it is using that to besmirch a trademark. And they've set up another dispute resolution procedure to look at the way when, say, if you had a domain name and structure devoted to Macedonians, for instance, is an area of dispute giving rise to some feeling, of course. How is the registry behaving? Is it allowing that process of issuing domain names in that space to be conducted properly and fairly, or is it not? So there's a special dispute resolution process there. And then if we go to the next slide, we will find, to no doubt your great relief, that we have come to the end of this, which is simply, I've omitted to put a photograph of myself there. I must reprimand someone on that, jokingly. But I simply say there that get in touch if I can help you on anything. I think we might leave it there because I have gone on and on, but I thought we should try and cover the field, and it may be, even if everyone else is bored with me, and my name is not Max Slattery, although Max, I hope, is there, and I hope I haven't put him to sleep as yet, or anyone else, but that is my view about the system. I think it's a good one. It's amazing that it functions at all, but it actually functions very well. And there's scope for improvement, I suppose, in some areas, but it's very good. Could I finish on one note? I just want to tell you just one thing to show you just how good this is, this system. I finished a decision yesterday for the forum, and without choosing the case, I thought I'll have a look at the last case I did to see how long the whole process took. And in this case I did last night, about midnight, I think it was, the complaint had been issued on the 3rd of June. The complaint was filed on the 3rd of June. The decision, my decision, was dated the 9th of July. Now, I think you would say that on any test in resolving any dispute, that's really not bad at all. From the 3rd of June to the 9th of July, the decision was released to the public and to the parties today, in effect, depending which country you're on, in the 9th or the 10th, was actually done prior to the 9th by some magic of the calendar, but the whole thing took 36 days from go to woe. And in fact, not only just 36 days, but 27 business days. That is really very good when you consider how disputes in this field could have been resolved, when you consider the time that civil litigation takes, often leading to no tangible result. It is really quite an achievement that the forum was able to get that case from go to woe from the 3rd of June to the 9th of July, finished, washed up, except for, of course, the 10-day pause at the end of the proceedings, just as a cooling off period during which court proceedings can be taken to set it aside. Not only, I hasten to say, did the forum do that, but other of the providers, of course, do their best to keep everyone up to the mark so that the essence of this scheme, which is that it is quick, is honoured. So I think that's the third time I've said that I'm finishing up, so I better live up to my word and say that really was it. So thank you for your attention, anyone who is still awake, and I wish you well in your work in this field. And please don't hesitate to get in touch with me or somebody else in the field if we can help you in any way. Thank you very much, and thank you very much again. Okay, bye-bye. Unless there are questions, we're going to deal with it.
Mr. Brown, there are some people who have some questions. Can we take those questions? Yeah.
Yes.
First one is by Tanya Patnakar. Her question is, what is the stand of ICANN with respect to grip sites / or suck sites, which uses the defense of fair use?
The defense of?
Fair use. Fair use.
What's that? I'm not hearing it correctly. The defense of serious, did you say?
Not furious, fair. Fair use.
Oh, fair use. I beg your
Yes.
pardon. I beg your pardon. Thank you. The attitude of ICANN to it, excuse me, especially I suppose being in the shadow of Los Angeles, is that they recognize the importance of freedom of speech, and that's where the gripe sites have their moment in the sun. Because by Jove, they say some nasty things about each other under the gripe site. But it's a price I think everyone, including ICANN, feels you have to put up with. It's a great value, and you know, the way in which the world is reacting at the moment to the concern about the suppression of freedom of speech in certain countries, which it's not necessary to name. But when you see that happening a lot these days, the importance of freedom of expression is good, and it should be encouraged. And ICANN does recognize the role of gripe sites and tribute sites. And as the questioner asks, what about fair use? Well, it's not really, I suppose it's the lawyer's answer when I say it all depends on the circumstances, but because it really does. I have seen them, and I've sat on them and decided them in every conceivable form of behavior, from mere commercial disputation to abuse and innuendo. It covers the whole of the waterfront. And it all depends on the circumstances. If it's so violent and extreme, I'm sure ICANN would take the same view that I would be, that you've got to draw the line somewhere. There is instance, what about the incitement to terrorism? The incitement to commit serious crimes? Should that be allowed? Probably not, I think most people would say. Okay, there was another question too. I saw it. I don't want to take it out of your hands, but it's probably the next one you're going to read out.
It is by Mahila Vinayagam.
No. Yep.
The question goes like this: is it, if at all, domain name is already registered in good faith, and the same is used in bad faith subsequently, what is the consequences?
Well, the consequences are that it's not been proved under the policy. It quite often happens, you know, that the domain name has been registered in good faith, in other words, innocently. Say when a generic name, a generic word has been used, say like liberty or freedom, and it's been registered in good faith because the registrant really did want to promote the cause of liberty or freedom or whatever it might be, and therefore constructed the website around that notion, that concept, and did not seek to damage the trademark or reputation of anyone. But then 5 years later, they found they'd really hit the jackpot, because lo and behold, there was a company that had appeared from nowhere who was using that name and using that trademark, who says, this is a slight on our reputation and you must hand it over. Well, the registrant has a very good defense. I registered this in good faith, not bad faith. Therefore, you have not proven it under the policy. Of course, I hasten to add, the registrant is not entirely out of the forest, not free from the jungle, because the trademark owner might take them to court or intimidate them, or may dig up some evidence to suggest, for instance, and this has happened, it may look as if they were lily right and well behaved at the time they registered the domain name. But now that we've found out this new evidence, this is a very different kettle of fish. I had a case, I don't want to again bore you with the details, but it was a masterly case, again one in the forum, where when I considered the complaint and the evidence in support of the complaint, I thought, yes, this, I think this makes the case out. Then when the respondent had its turn, it presented the opposite case, entirely opposite. But the complainant was able to come back and put in a further submission showing on very good evidence that the respondent had been wanted by the FBI and was up to all sorts of very bad tricks, and you could not believe a word they said. And the complainant was able to resurrect the case, if you like, and come home with flying colors and win the prize.
Yeah. Okay.
So,
Tanya has got another seeks your opinion on the case of ST Launder Incorporation versus Jeff Hanna. The issue is with respect to the freedom of speech.
Freedom of speech again, yes. We're very keen on freedom of speech. Yeah, that's good.
Yeah, she wants your opinion on that. Good. Yes, we'll go.
My opinion is that I forgot. I know the case is there. My opinion about that is I've actually forgotten what happened there. But I would say that it was a case, as all of these cases are inevitably decided on their own unique circumstances, and you really have to pay great attention to the evidence to make sure that you're doing no injustice at all. That's the important role. So I would be confident that it was dealt with along those lines.
It is nice to see that Mr. Philip has already answered Tanya on this question also, on the earlier question.
Oh, right. I hope we agree, do we?
Yes.
Good. Now, do you have one from Mr. Limbury there? Because he sent me one that he was going to ask.
Yeah, that is, I think he sent it by way of email. The question
Perhaps
is,
we've covered that already.
Yeah, the question is domain names cancelled following a successful UDRP complaint can be registered again. To prevent this, trademark owners tend to choose the remedy of transfer. This means they have to pay renewal fees for domain names they will never use. Should there be an additional remedy of burial?
Yeah, but just to make sure everyone understands the question, it's again this issue of a transfer by consent. What happens is the complainant makes its claim and the respondent, to everyone's surprise, jumps up and says, oh, look, this was all a mistake. I consent to the transfer. I consent. And the general rule is, it comes from the American legal system, I think, that if the parties have agreed or stipulated to a particular order, like transfer of domain name, the court or tribunal should stop there and not go on and give the analysis of whether the respondent had acted in bad faith or indeed anything else. Just leave it at that. And that is done. I have done that. When it's quite unequivocal that there is a consent to transfer, I agree to it. Now, the problem is about that sometimes it is done simply by respondents who want to avoid an adverse decision being made against them, because if it is, that will be used next time they come up in the next case. And it will be said against them, look, there were all these cases in the past where they stole people's trademarks. And look how bad, they lost 25 cases. So it is suggested that sometimes respondents consent to a transfer to avoid building up a record of lost cases. And what Alan Limbury is asking is whether can you deter that sort of behavior by imposing a fine of some sort or some other measure to, in effect, to punish recalcitrant registrants who engage in that behavior. Well, I have thought a lot about that over the last day or so, and I think the answer is yes, you can. You can do anything you like to restrict the process because it is all by contract, and if you can put it into the policy and people agree to it, then it's part of the contract which can be implemented. The problem about it, I think, would be, in Australia at least, and in some other countries, this would be regarded as a judicial process, the punishment, and therefore it could only be done by a court, not by an administrative tribunal. We have no power to do that sort of thing unless a court was set up to do it. And I think that would be the problem. And I think other people too would, some critics would say, really, is that what you should be doing? No, it's not what you should be doing. You should leave that to the parties to sort out. So I think my answer to Alan's question would be, and also my friend Philip Argy's put it in different words, but I think I was trying to get the same concept across. It's actually a penalty, and it's a financial penalty which is not only better left to the courts, but it's one where if it came up before a court, the court might say, well, it is a penalty, and for that reason it's not enforceable. So my answer, just to go back to Alan's question, my answer would be yes, you can do things like that, but I think you run the terrible risk of having it set aside and then your whole house of cards falls down. The other reason why I think, this is more a political observation I'm about to make, but I hope you'll excuse me, that it would require amendments to the UDRP. And the universal view has been that once you start fiddling around with the UDRP in even one clause, you're going to have enormous pressure to change a lot of it. They've been through this over the years with the UDRP, when allegedly freedom-loving countries like Zimbabwe and Albania at one stage and North Korea all wanted to do things they said were for the benefit of a new and better system. Complete nonsense, of course. They just want to get their hands on it. That's basically what they're on about. And they have always been hovering in the wings, ready to start their own campaign to change the UDRP. So in other words, part of my answer is to say, yes, you can do it, but you'll get a lot of opposition and it may not be worth the effort.
The next question is with respect to the arbitrability raised by our chairman Saranan. His question reads like this: whether the submission by a domain name applicant to arbitration of all disputes concerning the domain name in question can constitute a valid offer to arbitrate with third parties, claiming the registered domain name infringes on their right.
I don't think. Sorry.
In other words, what he's asking is, when a domain name is submitted for registration, they accept for the arbitration. But will it include a third party's claim with respect to the domain name, which infringes their right? That's what he wants.
Yes, it does. It does. It does because I think the answer is yes, it does, because the UDRP provision starts off by saying any person may bring a claim. And I think that's wide enough probably to get that sort of case in. But it has to be a claim about the domain name, of course. You would not have any jurisdiction to range any more widely. For instance, and it's another subject we can talk about,
Yes.
many cases we have raised this issue, namely, is what you are bringing before the tribunal a domain name case, or is it a trademark case, or is it a general commercial dispute? And panelists are very strong on this because they're very conscious not only that they should not go beyond their jurisdiction, but that there's always a possibility a court may come along and reprimand them for having done so. And we all like to avoid that sort of situation. So a general commercial dispute, which on the periphery touches on a domain name, but where the case is not really a dispute about the domain name, there is no jurisdiction over such a dispute. And quite often panelists have to write a decision saying, I'm sorry, we cannot decide this. You will have to go to the court. Good luck and goodbye.
There are a few more questions. Can I take it up?
Mm-hmm.
Okay.
Yes, my goodbye was not my goodbye to you. My goodbye was, that's what the panelist has to say to the parties. Go, goodbye. I'm sorry to trouble you. Yes, let us look at the last two questions.
Yes. Mr. Krishna Raj has asked a question. Is it infringement of the domain holder using the domain for a fair use and in a non-commercial way? Okay.
Sorry, go ahead.
What he wants to say is he is using a domain name which is similar, but it is not in a commercial way. Will it still be an infringement?
It could well be. It could well be. It depends on the circumstances, but the non-commercial aspect of it is often pivotal. Often the case swings on that. So as a matter of practicality, the answer is yes. That is important. It's not going to be a complete ouster or embargo simply because it's not being used for commercial purposes, but there are many cases. There are some, of course, that are expressly covered in the UDRP on that point alone, namely a general fair use excuse. I have a right or legitimate interest, and it's based on the fact that I'm using this domain name for a non-commercial use, such as a tribute site or such as just an ordinary site, but it's not commercial. It's an interest of mine, a hobby, an issue I'm concerned with, a political issue. And if they prove that there's no commercial element at all, then yes, that strengthens their case. One interesting thing that is hard for panelists to resolve is, does the slightest commercial involvement tarnish their whole performance? That case I mentioned before, the Legend of Zelda one, which the registrant won. The registrant, young Alex Jones, was successful because the website was 99% simply informative. It was gossip and intrigue, character development, news and entertaining. But he did include on his website where you could go off and buy little bits and pieces, perhaps costumes, something like that, to show you were a real devotee of this Legend of Zelda. And the arbitrator said something like, of course it is true that this website has a small commercial element to it, but it is de minimis. And we should not let ourselves get diverted by the fact that it is de minimis. There's a little bit of commercial activity, but it does not colour or dilute the substance of what he is doing. So the answer is yes, I think.
Parvati Prasanna has got a question. Her question is, in practice, does the registrant get the benefit of doubt if the disputed domain name is generic or very descriptive? And she also wants to know whether the domain name precedents are being followed.
Okay, the first one, the answer is yes, although I would not use those words. It's not so much the benefit of the doubt, it's the fact that if it's a generic word used in the domain name, and genuinely so, and not a cover or device to have a go at a trademark under the table or behind the scenes, then yes. But the panelist will not say, oh, well, it's hard to decide, but I'll give the benefit of the doubt. I suppose that could be said, but generally it will not be said. What it will be said is, if your defense is that this is a generic word and you are using it in a generic way, how does it come about that you are in effect advertising a rival product? You are using it not in a generic sense, but in a trademark sense, either to copy the complainant's trademark or to undermine them or to support a rival or something like that. So in other words, the answer is that they would not use those expressions except in a case where it was really justified to call it, I'll give you the benefit of the doubt. But in practice, the issue will be, does the evidence show that you're using it genuinely in a generic sense, or is that a cover to use it in a trademark sense? So yes, but a lot of cases will, some cases will succeed if you can show I'm using this word in a generic sense, and I actually used it always in that sense. Some panelists would say you must prove that, and that's a good working rule. Now, the last issue you've raised, we could be here for another hour tonight on this issue because it's a controversy. You see, WIPO quite often refer to decisions as precedents. They are not precedents at all because they're not in a hierarchy of courts. And secondly, some of them are conflicting. So if they're precedents, which one do you choose? How do you decide to support this one rather than the other one? They are valuable tools, decisions of panelists, because they show, especially when there is a trend in the one direction, they show the general disposition of panelists on particular issues and are valuable to that extent. And they're also valuable as a guide to potential complainants. Should we file this complaint or not? Well, it looks as if we will lose. So we will take that into account. Others would say, no, let's have a go at it. It doesn't matter. Our facts in our case are different from the facts in the alleged precedent. Therefore, we can still be confident of winning. But they are not precedents, but they are good guides, especially, as I say, when there is a trend, and especially when they are decisions of arbitrators, panelists who are experienced and respected. Parties will obviously give great credence to those. So they are useful, and I would be the last person to say we should not have them. But I do tend myself to start every case with a clean slate.
Okay.
That's my defense.
Okay.
All right.
Mr. Amol Dalela, he wants to know what is the strength of the panel members in WIPO and how to get empaneled, and what are the eligibilities?
To become a panelist?
Yes, in WIPO.
Yes,
WIPO.
okay. What you can do is to write to the providers and say, I am very interested in this field. I have had a bit of experience. I studied intellectual property. I follow it with interest. I would like to try my hand at it. And then you would be considered. That it's basically for the provider to decide who is on their wider panel and who is not. And that's really all I can say about that. Other than good luck. Good luck.
Okay.
All right. Can I? Oh, sorry. Another one?
Yeah, two more, I think. Ms. Ritika has got a question.
We're into overtime now.
Okay.
Sorry. Go on. It's all right.
Okay, I'll go with this one and one more alone. What is the position of websites made for fan fiction, especially when they have confusingly similar names and have the possibility of finding commercial use subsequently?
I missed a few words there. I'm sorry. Could you paraphrase that?
No, what she wants to say is that there are certain websites which are made by fan fictions, and subsequently
sorry, did you say science fiction?
Fan fiction. Fan fiction.
Oh, fan fiction.
Yes.
Yes. Okay.
And subsequently, they are so confusing and similar to the possibility of finding a commercial use. What happens then?
It sounds as if it might be one of those cases where the domain was registered in good faith at the beginning, and then they hit the jackpot a few years later and could see themselves leading a life of idle richness, to living on the proceeds of selling the domain name to Giorgio Armani or anyone else. So I suppose that could be such a case. Again, it all depends on the facts. It all depends on the evidence and presenting the evidence. It really does.
So the final question is from Anand, our secretary. Does UDRP decision follow due process of law, fair hearing, minimum standards, and equality?
Yes.
When the respondents get 21 days to file the reply and the complainant has no right of reply?
Ah, I see. That is true, but the complainant has the right to apply for that, the right to request it, and if it's new material and a new argument, the panelists will usually say yes, because they're curious to know what this new material. But I can understand where the question comes from, but it's not a major practical hurdle. The bigger practical hurdle, frankly, is where they do put in an additional statement and it merely repeats the assertions of the first time around the mulberry bush. They just want to go around again and have another go. So that I think is the answer. It's a good balance where it is at the moment. The balance where it is that you have one chance. You put it in your complaint or you put it in the response, and that's it, end of subject. But there is a right to ask for leave. Looks like there's been a coup there. I have a different person in front of me. Has there been a revolution while we were talking? No, you're back again. There's a counter-revolution. And I think I think it's a good balance where it is at the moment. They have one go, and it sometimes they need to be told that you really should have put all this in the first time around. You're just simply trying to repeat it, and we will not receive it. The essence of the whole process is that it is quick and not overly legalistic, and therefore we believe that in substance the exchange should be one time to each side, unless there is something you could not reasonably foresee which has been brought up against you, and therefore you have the chance to have a second go at it. I'm sorry to interrupt you, just one other point. It's interesting, you've reminded me of another problem that arose, which I had. Just for a minute, I'll tell you part of it, which is where a party, makes a proposition and the panel on its own initiative asks for more, and the party still can't get it right. Either they ignore that request, or when they come back with their additional submission, they either do not answer the question put to them. Just to give you one example, there was a case concerning, the soccer player Pele, and the registrant had used Pele's name as part of the domain name. And he said in his defense, "Oh, but Mr. Pele has written me a letter. Mr. Pele has written me a letter." I don't know if you can still hear me. I hope you can.
Yeah, we can.
Oh, right. I can't see you now. It doesn't matter. Mr. Pele has written me a letter, and he said he says he agrees to using his name in the domain name. So the three-person panel issued an order and said, well, okay, if that's the case, produce that letter from Mr. Pele. And then there was profound silence, no more communications from the respondent. So it was obvious that it was misinforming the panel, and the panel took exception to that. Naturally, the case was decided for the complainant. Okie doke. If you're still there, let me say it's been a great pleasure to spend a night with you, or a morning or afternoon, as it is in some cases. Let us hope there are some more. I think there is a very good case for having it sounds a bit boring, but it's quite interesting. There's a very good case for having a webinar on evidence, and there's a good case for having a webinar on procedure. It sounds a bit boring, the latter, but very important, and it's where a lot of people get tripped up making mistakes on procedure. But whether they happen in the future or not, it doesn't matter. We've had I think, an enjoyable and I hope useful and instructive meeting. Thank you very much.
Thank you, sir. We also thank Mr. Philip, who had been very supportive in the chat box, has been answering many questions which was posted there. A special thanks.
Yes, I've noticed. I've noticed, yes.
Now I call upon Mrs. Harini. And before that, I would like to make an announcement that already I have put in the chat box the feedback form. Kindly fill up the same. And
Okay.
for the 17th of July, we have the next session. The topic will be the success story of the Singapore International Arbitration Center, SIAC, and it will be spoken by its CEO, Ms. Lim Sok Hui. And now may I call Harini Narayan Sami to render the vote of thanks.
Okay.
Many thanks to Honorable Neil Brown for providing this audience with several insights concerning arbitration and domain name disputes. It was truly very useful and insightful talk. And your talk has thrown light on the fact that we've had some 50,000 cases, which makes it one of the largest areas of arbitration. And there are 6 main service providers in this area. And the UDRP process being very quick and efficient and economical, making it also a plaintiff's heaven, where 70 to 80% are successful cases in favor of the complainant. And you've also touched upon types of domain name disputes like commercial disputes, cyber squatting, fraud, counterfeiting, pornography. And you have discussed, of course, the 3 UDRP elements and touched upon some of the differences between the UDRP and some of the country name like the .in dispute resolution services. And you've also touched upon some of the interesting cases in this area like the AR Money case, the Armani case, and Gary Jennings, Legend of Zelda. So many thanks again. And also thanks to Max to have helped with tech support, to the speaker, and CNICA for having organized these tremendously interesting events every Friday, which we all look forward to. And I thank all friends and colleagues who have attended today's session.
Good. Thank you very much indeed.
Thank you, one and all. Now I take your permission to close the meeting. Thank you.
Yes, okay.
Thank you.